All right. Well, welcome everybody. This is my first virtual webinar, video webinar in a while. So hopefully everything will go smoothly. If you have any questions or concerns, just go ahead and type in your question and Dan will let me know that there's an issue because I don't know why I can't see it, but anyway, I just wanted to first of all thank you all for attending. I know all of you have continued to work throughout the pandemic, as have we, and we've all kind of struggled to navigate through this time. And I hope all of you are healthy and that your families are healthy. So anyway, so welcome. So we have limited time and a fair amount of content. So one of the first things, well, obviously you can read the slide. We're going to talk about often overlooked Georgia employment laws. But before we get into the actual overlooked laws, I wanted to make sure that all of you were aware of the Georgia COVID-19 Pandemic Business Safety Act legislation that was passed by the Georgia legislature back in June. There was a little bit of publicity about this, but not a ton. And basically, you guys have probably heard about it, but it does protect, to some extent, certain entities, and you'll see that it includes governmental bodies, against claims relating to any type of COVID-19 liability, if you follow what is required under the statute. So this legislation is set to become effective next Friday, August 7th. And so the way that the legislation was written was that it would either be effective upon approval by the governor, upon it becoming law without such approval, or on August 7th, whichever comes first. And so at least as of right now, I'm not aware that the governor has actually signed the legislation. So at least as of right now, it should go into effect next Friday. And again, it provides protection to businesses against claims related to COVID-19. And you can see all of the governmental bodies that are included in the definition of entities. And so the language of the legislation provides that except for gross negligence, willful and wanton misconduct, reckless infliction of harm, or intentional infliction of harm in an action involving COVID-19 liability, claims against an individual or entity for transmission, infection, exposure, or potential exposure of COVID-19 to a claimant on the premises of such individual or entity, there's a rebuttable presumption of an assumption of risk by the claimant. And in order to take advantage of that rebuttable presumption, you have to have a sign at a point of entry that has the specific language here on the slide. And one of the things that I wanted to make note of, the version that I sent over to Dan, I had missed a very key piece of that language, which is the warning language. So if you haven't done so already, what I would highly recommend is to go ahead and prepare a sign with this language. I would probably have it as a standalone if you don't have something like this already. And it says 1-inch Arial font, and it should be standalone with this language on it. Warning, under Georgia law, there's no liability for an injury or death of an individual entering these premises if such injury or death results from the inherent risks of contracting COVID-19. You are assuming the risk by entering these premises. So I will note, however, this doesn't impact any other potential claims like under workers' comp. However, under Georgia law currently, there's not been any amendments that would make it likely that somebody who contracts COVID-19 at work, assuming that you could trace it back to work in the first place, wouldn't be able to, at least under the current legislation, probably wouldn't fall within the workers' comp laws anyway. So anyway, this really will protect you against claims of negligence. And as long as you're following all the guidelines that are out there from the CDC and the Georgia Department of Health, then you guys should be good to go. So if you have questions about that, you can feel free to contact me after the webinar for more information. But I wanted to make sure that you guys were all on top of that. All right. So the Georgia Whistleblower Act, we all know that it's out there, right? And we all know that it protects against claims of retaliation. The legislation itself protects against disclosures by employees of a law, rule, or regulation, okay? And so a lot of times what we'll see these claims kind of tacked on to other retaliation claims under Title VII, the ADEA, the ADA, other federal discrimination statutes that have retaliation claims. And the one concern about these Georgia Whistleblower Act claims, at least for us as lawyers, is there isn't any cap on damages. So compensatory damages, for example, for emotional distress damages, there's no caps, whereas as most of us know under the federal legislation, there are certain caps on compensatory damages based on the number of employees that you have in your governmental agency. So what is a law, rule, or regulation? So back in 2017, there was actually a Georgia case that helped us define what that was, because for a long time, we were kind of out there, trying to guess what that really means. A law, rule, or regulation. Does that mean our policies? Does that mean, ordinance? Does that have to be a statute? And back in 2017, the Georgia courts clarified for us that it actually, in order to be protected under the Georgia Whistleblower Act, it has to be a disclosure of a federal, state, or local statute or ordinance. So a real legislation of some form, or any rule or regulation adopted according to any federal, state, or local statute or ordinance. So this clarified for us that claims under the Georgia Whistleblower Act, they can be brought, but they won't be meritorious for claims that you violated, say your internal policies, for example. So a protected disclosure under the Georgia Whistleblower Act is one relating to an actual or perceived violation of one of these federal, state, or local statutes. So, arguably, not arguably, but what it would include, a disclosure of a complaint of discrimination, for example, under Title VII, would fall within the scope of a Georgia Whistleblower Act claim.
Hey, Tracy?
Yes, Dan.
I have a few questions. One, does this cover or include places of worship?
Well, it only applies to public employers.
Okay. Should this be placed in each public building?
Oh, I see. You're back a slide. Here.
Okay.
You're here, right?
Yes. Yep.
I'm like, wait, what? So you're talking about the COVID-19 language?
Yes.
Got it. You know what? I only focused on the government piece of it, and it's certainly not limited to just government. It's written pretty broadly. It says associations, all sorts of businesses, healthcare. There are specific language related to healthcare facilities, but I don't know that for certain, and so I would have to get back to you on that. So I don't think I can answer that question at this moment.
Okay.
And did you have another question about that particular slide?
It should be placed in public buildings. Let's see, will you send us language for the warning?
Yeah, it's on the bottom of the slide.
Okay.
Yeah, so the language that I've bolded at the bottom, starting with warning and then the bolded language underneath it, that's what has to be on the sign.
Okay.
Yeah. And then you would want to put it at a point of entry or every point of entry into your building. But, you know, if you're going to pick a couple places, I would do any public entry way to any of your government buildings. Okay.
Go.
All right. Sorry. Oops. All right. So back to the Georgia Whistleblower Act. So I think for the most part, you know, a lot of us who have been doing this a while understand that there's a claim out there under the Georgia code for a whistleblower claim, a retaliation claim. But we wanted to point out there's a couple other parts of that particular legislation that we wanted to point out as part of this presentation today. One of those things is it talks about the inability to disclose the identity of the whistleblower unless you receive permission from the whistleblower, or if it's necessary and unavoidable as part of your investigation, you have to provide notice to the whistleblower 7 days prior to your disclosure of the identification of a whistleblower. So, you know, I think for the most part, when we're doing investigations, you know, there is a certain sense that the respondent to a complaint, you know, has the right to know who the person is that's complaining against them. And depending on how you conduct your investigation, you may or may not disclose that information, at least at the outset of the investigation. But with respect to any type of disclosure or complaint that would fall within the Georgia Whistleblower Act, just be aware that there is a prohibition on the disclosure of the identity of the whistleblower, except in those particular circumstances. All right. All right. So another thing we wanted to point out was refusing to participate in an activity because the person thinks it's a violation of law. I mean, it really is a law, right? It's got to be a statute or ordinance of some kind. So if somebody believes that you're asking them to participate in some activity that they reasonably believe is a violation of law, they're protected from any type of adverse activity based on that refusal to participate in that particular activity. And another thing too that comes up sometimes, not necessarily related to complaints under the Georgia Whistleblower Act, but just in complaints in general, where mostly in public safety, where you've got sort of the chain of command structure, and there's a requirement that any issues you have to be pushed up through the chain of command. So if you're going to complain about something, it first has to go to your supervisor, and then the supervisor above that, and so on and so forth. And, you know, we've talked in our trainings before about complaints under some of the federal discrimination statutes, where you have to have an alternative complaint procedure that allows an employee to bypass their direct supervisor in the chain of command when making complaints under that federal discrimination legislation. And this applies similarly here under the Georgia Whistleblower Act. So just be cognizant that you don't have policies that require following the chain of command for Georgia Whistleblower Act types of disclosures, and that there's always an alternative method of complaining. And if you don't have something like that in place, you know, one way or the other, if you are going to take some type of action or contemplating taking some type of action because the person didn't follow the chain of command, it's just one of those things to consider before implementing that protection. So, and I actually had a situation recently where somebody sort of went to another public agency to disclose what they thought to be some misconduct by their particular department, and there was some concern that that individual didn't raise the issue internally before they went to an outside agency. And the Whistleblower Act was one of the things that we had to give consideration to in advising the client about whether or not we would advise that action be taken based on circumventing the chain of command. So, all right. So municipal court judges. So this was kind of new to me, actually, because I've never really dealt with it. And I deal kind of more on the employment side of it, although your city and county attorneys are probably more familiar with it. But municipal court judges, I guess prior to July of 2016, they served at the pleasure of the governing body. So they were at will, just like most government employees are, unless you've implemented some type of policy, handbook, charter, rules that would alter that at-will status. But back in 2016, the legislature took that at-will employment status away from municipal court judges. So I guess it was in an effort to protect the separation of powers, your judicial from your legislative powers. And so, and I guess to protect the judges from kind of serving at the whim of whatever group is in power at the time, I suppose. But in any event, know that if you are involved in that process, that they now do have due process rights. So you can't remove them from their job without due process, which we'll talk about in just a minute. And this also, to the extent that you would have charter provisions purporting to maintain a judge's at-will status, this supersedes any of that language. Okay, so under the newly amended law, judges must be appointed to a minimum of a one-year term. So not unlike probably most of your city and county attorneys, they enter into a one-year agreement, appointment at the beginning of the year, and they serve for 1 year. They cannot be removed at any time prior to the expiration except for cause, okay? Determined by 2/3 vote of the entire membership of your governing authority, which, you know, for the most part is going to be your city council. So what is cause under the statute? Willful misconduct in office, willful and persistent failure to perform their duties, habitual intemperance, conduct prejudicial to the administration of justice, disability that interferes with the performance of duties that is likely to become permanent. So, I mean, there has to be some pretty serious issues going on for the governmental body to have cause to remove a municipal court judge. The statute also does provide, I'll make note, that the city itself can define additional conduct in their charter, in addition to some of the other causes that are set out in the statute itself. And there's also one other exception for any of you that are part of a consolidated government. For municipal court judges serving in a consolidated government, your local act will determine the term of for that particular judge. Okay. All right, so let's see. Removal, the statute establishes the process for removing a municipal court judge, which is formal, and it's not unlike most due process proceedings where the person is entitled to notice and an opportunity to be heard and to respond to the charges against them. And so if you ever find yourself in a position of removing a municipal court judge, I've not had this experience before, but so you understand the process. It's initiated by petition by one of the council members. The judge gets a copy of the petition, which lays out the cause for removal. and then the judge is entitled to a full due process hearing. And that procedure itself is subject to administrative review by the Superior Court through the certiorari process. And so because it is subject to review, just like any other real, true due process hearing that can be reviewed by the Superior Court, I would recommend either video recording the hearing or at a minimum audio recording the hearing. And if neither of those two are available, having a court reporter there who's taking down testimony from the hearing. Okay. And then the last thing is that, as you'll see on the slide, that the statute permits the judge to be suspended with pay for up to 60 days pending removal proceedings. All right. So hopefully that's not a common exercise. All right. So some of the Georgia EEO laws, and just to be honest with you, I really wasn't aware of a lot of these until, maybe about 5 years ago, even though I've been practicing in Georgia for 12, because you never see them. Georgia is a strong at-will state, and as you'll see as we go through these, why these claims really don't make their way into courts. I mean, they really don't have a lot of teeth to them. And I think for the most part, they're really sort of symbolic gestures from the legislature, which ultimately don't really get enforced. So our legislature, Georgia is, again, it's a strong at-will state compared to a state like California, where I started to practice law, where they have much stricter EEO laws that, all the time you're in state court because there's more relief available under their state code than there is under the federal code, which is unlike Georgia. So anyway, just for your own edification, again, I don't know that you'll see these claims very much, but in the event that you do, you know that they're out there. And the good news is that if you're following the federal statutes, for the most part, you're going to also be complying with the Georgia statutes. All right. So Georgia does have an age discrimination or anti-discrimination law. And we've put the actual location in the code if you have specific questions about it. But it prohibits age discrimination in hiring and firing, except where justified by the reasonable demands of the position. And all that means is you have to be qualified for the position. You can't just refuse to hire or fire, or can't refuse to hire or fire anybody solely because of their age. And this is limited to hiring and firing, whereas if you're familiar with the federal age discrimination legislation, it prohibits discrimination related to a number of other adverse employment actions. So any type of disciplinary action that would be considered adverse. Both statutes apply to anybody who is 40 and above. However, the Georgia code limits protection under the Georgia statute to individuals who are between 40 and 70, whereas the federal legislation does not have a cap on age. And as a matter of fact, I had a claim a number of years ago that was brought by a 72-year-old police officer. So just again, if you're complying with the federal discrimination statute, you're going to be complying also with the state statute as well. It conditionally permits mandatory retirement at age 65 for certain bona fide executives. This is really not going to apply to much other than probably your city or county manager, somebody who's in a high policy making role. And this actually tracks the federal legislation as well. And there's certain requirements that have to be in place in order to permit the mandatory retirement. It has to do with certain protections of pension and those types of things in order to be able to fall within this exception. And I know this is going to blow you away, but you can be held criminally liable if you violate the statute. it is a misdemeanor to violate the statute, but it doesn't provide a private cause of action. So either the state or local government would have to file a claim or bring a charge against you for violation of the local age discrimination legislation. And believe it or not, I don't know anybody that's ever been arrested for violating the statute. So, so there's a silver lining there. Okay. Let's see, Sex Discrimination Employment Act. Again, this sort of tracks the Federal Equal Pay Act, if any of you are familiar with that, and it prohibits sex-based wage discrimination, so salary discrimination. The federal legislation has actually been in the news over the last couple years, and you may have seen some cases that have come out saying that you cannot base initial salary on past salary. So when you're asking salary history, you can't hire someone at a higher salary rate for the same job that somebody may not have been making a similar amount of pay in their full job. So even though it's a little bit more, it has to be equal from a sex-based perspective. Now, this does not take into consideration or does not exempt you from considering things such as your seniority system, your merit system, production-based system, or other non-sex factors. So, so just because you have two people, a male and a female, doing the same job, if somebody has been there for a longer period of time and has had merit increases along the way, that's not going to be impacted by this particular legislation or even the federal legislation. And then under the state law, there's a 10 employee threshold in order to be covered by this particular legislation, which I think probably most all of you meet. There might be a couple very, very, very small cities that might not meet this employee threshold. But nevertheless, know that you have to have at least 10 employees to fall within this particular legislation. Similar to the federal legislation, there's also an anti-retaliation provision that's part of this. And so we put a note here that the Georgia Whistleblower Act would likely also apply to any retaliation cognizable under this particular statute, since it's a law, rule, or regulation. So if somebody were to come and complain about salary disparity that might fall within this particular law, that would also could give rise, I guess, to a claim also under the Georgia Whistleblower Act, which, as we talked about, has more availability of relief in terms of damages than some of the other legislation. And I think right here, yeah, so this authorizes the cause of action for limited monetary recovery equal to the amount of unpaid wages. So, I mean, really, you're going to be limited to probably the difference in whatever the person claims they should be receiving versus what they're actually receiving. So all in all, it's probably not going to be very much money that you're talking about here. And then there's also a provision for the award of attorney's fees not to exceed 25% of the judgment amount. So, if you think about it, if you're only entitled to the differential, and it's $1 an hour or 50 cents an hour, depending on the period of time that it covers, and you'll see below, there's a 1-year statute of limitations. You're probably not talking about more than, I don't know, a couple $1,000. And then if the attorney only gets 25% of that, the time and money spent to litigate a claim under this probably is not very worthwhile, which, again, you're better off filing under the federal wage discrimination laws. All right. Oh, I was also just gonna make make the point that there's actually, for violating the retaliation provision, $100 fine for conviction of the retaliation provision. So, you know, again, I think these are just symbolic gestures to show that the legislature is thinking about it and cares, but not really that much. That's just my perspective. All right, so let's see. The Georgia Code also has a anti-discrimination for persons with disabilities provision, similar to the Americans with Disabilities Act. And here it prohibits employers from discriminating against any person with a disability with respect to wages, rates of pay, hours, or other terms or conditions of employment because of the disability, unless the disability restricts the person's ability to perform the particular job or occupation. So, I mean, again, that's similar to the ADA in a sense that you're protected as long as you're qualified to perform the job, as long as you're able to perform the job. This is also in terms of who's covered under this particular law. They still have the same 15 employee numerosity threshold as the ADA does. And then again, it's the definition of disability is similar to the federal ADA law, but it contains more exclusions. So for example, addicts, even alcoholics are not covered within the definition of disability under the state law, whereas under the federal legislation, as many of you probably know, alcoholics are covered under the is a disability. Alcoholism is a disability. And unlike our federal counterpart, the state legislation doesn't have any reasonable accommodation requirement. And it also does not, it also only covers individuals with an actual disability and a record of disability, whereas the federal legislation covers individuals who are regarded as disabled. So there's a little bit more, a lot more broad coverage under the federal legislation than the state legislation. And here it authorizes the cause of action for equitable relief, including reinstatement and back pay. Again, there's no relief in the form of compensatory damages, whereas under the federal legislation, again, depending on the number of employees that you have, the compensatory damage cap is anywhere from $50,000 to $300,000. So you can see why it's why individuals would much rather follow under the federal legislation than the local law. There's also no right to a jury trial, and like federal law, you get a jury trial. Both authorize awards of attorney's fees, and then here there's a 180-day limitations period, which is the same for ADA. You have to file your EEOC charge within 180 days of the employment action that's complained of. Okay, so really, I guess if you wanted to litigate in state court and you had a claim for disability discrimination, you know, you would at least get, you know, whatever money that you're out as a result of the discrimination, and so you could be made whole. You're just not going to get the extra award of compensatory damages. All right. So many of you have probably been dealing a lot with this lately, which is time off to vote, which is codified there in Title 21 of our code. And this applies to all employers, including local government employers, right? And then it requires that employees be permitted at least 2 hours off to vote in any municipal, county, state, or federal political election. All right. Sorry, I'll make a little adjustment to my screen. So really, except for your employees who are working maybe 12-hour, 24-hour shifts, for the most part, I would imagine that you all can accommodate the 2-hour on the beginning or the end of any type of shift, so that the employee doesn't need to have the 2 hours off and can vote either before or after work. Although, I mean, it sounds like a lot of you are also very flexible in that, and you'll go ahead and schedule it accordingly, let people go during the day or allow them to take time off during the day. But that really is, that's a matter of policy, how you want to handle that. The employee must be a registered voter for the election in question. They must provide reasonable notice of the need for time off to vote. And then, you know, again, as I mentioned, it's not applicable to those whose shifts begin where they have at least 2 hours before or after their shift where they would be able to vote. And then the employer may specify when the employee takes time off to vote. So again, according to, you know, what makes sense in terms of your operations, you can sort of dictate if they're not going to vote before or after work, you know, you can make arrangements for when they can go. And there's no requirement under the law to actually make that time off paid. So again, that's also a matter of policy if you decide to want to pay for that time off. All right, jury and witness duty also has certain requirements for local government employers that require you to allow employees to take time off to attend jury duty or court proceedings when they're subpoenaed or summoned. And so if you have anyone who claims that they have either been summoned for jury duty or that they're attending any other court proceedings, you can always ask for their subpoena or their summons to confirm that in fact they have been called up for one of those court hearings. So is this time paid? For jury duty, even though the statute itself doesn't contain any particular language requiring you to pay for time off for jury duty, there is an old Attorney General's office opinion out there that suggests that the time off for jury duty must be with pay. And I guess that's probably because in the statute, employers are prohibited from penalizing employees for serving in jury duty. And so taking away their pay could certainly be considered penalizing them for having to take off time for jury duty. And it's also a civic duty for all of us. So we certainly don't want to penalize employees who are called in and mandated to serve on jury duty. However, regular witness duty doesn't necessarily need to be paid. There's no requirement that that time off be paid. But oftentimes employers will have policies that if their time off is related to their job, then that time will be paid. But if it's personal, then they're going to have to use some other form of accrued leave to cover that time. You can always check the, you know, I would always request a copy of whatever documentation they have that's calling them into court or a deposition or something along those lines. So if it doesn't appear on its face to be a valid subpoena, there's no requirement that that person be allowed time off. And then where the legal proceedings relate to a crime committed by the employee or allegedly committed by the employee. So if they're a criminal defendant, they don't necessarily get approved time off for participation in that hearing. The cause of action for violating this particular statute is actual damages. So and what is that really going to amount to, right? If you don't pay them for a day, maybe it's a day's worth of pay or a week's worth of pay. But beyond that, unless you terminate them, that would obviously result in a higher damages claim. But for the most part, it's going to be minimal. And then it also does authorize an award for attorney's fees. And then one thing we wanted to point out, and actually I do have this particular claim is part of a RICO claim in current litigation, but there is a particular criminal statute that talks about any person who, with the intent to deter a witness from testifying in any matter or proceeding, any matter pending in any court, in any administrative proceeding or grand jury, communicates to the witness any threat of damage to their employment. So, you know, if you go there, if you testify to this, you know, you're going to lose your job, something along those lines, is punishable by imprisonment of no less than 1 nor more than 5 years upon conviction. So you certainly don't want to be charged with interfering with somebody's testimony in court. All right. And blood donation. This is something I don't see very often. I actually don't see it in many policies either. But there is a provision in the code that entitles local government employees to receive up to 8 hours of paid leave per calendar year for the purpose of donating blood. And then that leave has to be taken in 2-hour increments, and it can be done up to 4 times a year. And then similarly, local government employees can receive up to 16 hours of paid leave per calendar year for the purpose of donating blood platelets. And again, those are broken up into increments of 4 hours up to 4 times a year. All right.
Tracy, we got a question here, a couple questions.
Yeah, sure.
Do employees get paid regular pay and the jury pay for jury duty?
So that's really a policy decision for you. They have to at least make what they would, what their regular salary would be. And I think they get a nominal amount for jury duty. So, I mean, you could, it's not unlawful to make up the difference between what they get in jury duty and what their regular pay is. But I think for the most part, because it is sort of nominal, I think employees just go ahead and continue to pay them their regular salary during that time.
And here's if you would, let's see, Jodan Thompson says, if you'd please remind ACCG IRMA members have access to HR helpline. So that's, again, something that's actually a good thing to remember. Both GMA and ACCG have access to that. I'll let you continue.
All right. Yeah, and so the helpline, actually, if you do have access to either our helpline or the helpline through ACCG, you know, well, of course I'm a little biased, but you know, I do think it's helpful to go ahead and utilize those helplines just to talk through, you know, especially if you have a complicated issue or a sticky issue that you're not sure about, just to get the legal advice. To make sure that you're on the right track. And I know oftentimes we'll, you know, review letters and, you know, help ghostwrite things for our clients through the helpline, with the sort of mind that at some point later on down the road, if that particular situation or issue ends up in litigation, that we've helped set up a solid defense for the employer. So yeah, so that's a good point to go ahead and utilize those services that are available to you. All right. And then the last thing I wanted to talk about today, and we've done a whole presentations on this topic, and so it's going to be pretty pared down, but I will say that this is probably a fairly commonly overlooked Georgia employment law related to constitutional due process. You know, a lot of times we talk about at-will employment unless you can only terminate your employee for cause, in which case you have created a property interest, a constitutional property interest in their employment. And the only way that you can take that away is by providing notice and an opportunity for the employee to basically fight the charge. And so I think everybody's familiar with that, but what commonly gets overlooked is also in the due process clause, it is you can't deprive a person of life, liberty, or property without due process. And so the liberty interest provision of that also applies to government employers as well. And that is, you'll see different names, either liberty interest hearing or a name clearing hearing is oftentimes what it's referred to in policies. And so really what a liberty interest is just think about it in a sense that it's really the right of the employee to pursue their chosen profession free from government interference. And so what does that mean? Well, if somebody is terminated for a reason that might be stigmatizing, that might effectively remove them from that particular profession as a result of the alleged conduct that they engaged in, they have a right to a liberty interest or a name clearing hearing, okay? And so what does that mean? Only discharges for stigmatizing reasons implicate an employee's liberty interest. And so, what does it mean to be stigmatizing? And I think about it like this. If there are certain things, if you're going to hire somebody for a particular position, you know, are there certain types of conduct out there that would absolutely preclude that person from any consideration for that job? And those would be things that would be stigmatizing. So, for example, a police officer who's fired for stealing or other criminal activity, because the police officer exists, that position exists to enforce the law, right? And so it's counter to the reason for which the position exists. A firefighter fired for arson. A firefighter is supposed to fight fires, not start fires. A bookkeeper fired for embezzlement. Well, a bookkeeper is supposed to maintain the accuracy of the books. And if they're stealing from the books, that is counter to the job for which they were hired. And nobody's going to hire a bookkeeper who was charged for embezzlement. A teacher or a coach fired for an inappropriate relationship with a minor, right? A teacher or a coach is a mentor. They're in a position of mentorship and leadership. So if you're abusing that relationship, you are not going to be hired, or I would imagine most places, you will not be hired again for that particular job. So when I think about stigmatizing, those are the types of conduct that I would consider stigmatizing. You have to look at the position itself to determine whether or not it's stigmatizing, because it's not going to be for every profession necessarily. And it's going to be limited to unethical or immoral type conduct. Again, that type of conduct, which if you saw that on somebody's resume, they're not even going to get a second look from you, right? Lying, cheating, stealing, you know, conduct that violates the position of trust. If you terminate someone for a reason that's not stigmatizing, they don't have that right to a name clearing hearing or a liberty interest hearing. So some examples of conduct that's non-stigmatizing for the same professions that we just talked about are a police officer fired for sleeping on duty, right? I mean, the chances that the police officer is going to find another job in law enforcement, you know, at least given where we are today, are probably pretty high, right? A lot of people can overlook someone falling asleep on duty, especially if they work the night shift. Firefighter fired for poor attendance. You know, again, these are things where, you know, they're not going to be positive factors, but they're not going to remove them from consideration necessarily, unless there's more to it. A bookkeeper fired for negligence. If it's not really related to the job duties, is that really going to implicate the ability to find work? A teacher or a coach fired for poor performance. Again, it's not something that's going to foreclose employment opportunities down the road necessarily. Some examples of reasons for discharge that may or may not be stigmatizing depending on the circumstance, and that's why we say The analysis is often conducted in gray areas because a lot of times, you know, maybe there isn't something that's that obvious on one side or the other, but depending on the circumstances may shift the balance in one direction or the other. So a police officer who's fired for poor gun safety, you know, there's a distinction between an accidental discharge that goes off in an empty field versus an accidental discharge that hurts somebody or kills somebody. A firefighter fired for wrecking a fire truck. Well, heck, probably most firefighters have done some wreck of a fire truck, or, you know, those things, you've ever driven a bus before or a long van, those things are hard to maneuver. But, you know, what was the context in which the truck was wrecked? How many wrecks have you had? That type of thing. A bookkeeper fired for leaving the cash drawer unlocked. You know, was money stolen? Was it inadvertent? You know, was it intentional? Was it negligent? You know, context matters. And then same thing, teacher or coach fired for excessive non-physical discipline of a child. You know, that may not necessarily foreclose employment opportunities as a teacher or a coach in the future. All right, so here's some additional gray areas. We just wanted to give you some examples to think about next time you have to terminate somebody, because these liberty interest hearings arise in the context of a termination, okay? So we're not just talking about a suspension or some other type of disciplinary action. They do arise in the context of termination. So what about a department head fired for sexual harassment? Does it make a difference if it's a public works director with no female subordinates versus the HR director who's responsible for enforcing and conducting training on the anti-harassment policy? You know, again, going back to what is the reason why the position exists? Well, the HR director has the responsibility of enforcing anti-harassment policies. So engaging in harassment is counter to that person's direct job responsibilities. Whereas not so much with the public works director. The employee fired for off-duty domestic violence. You know, what if it's a police officer? Again, police officers are charged with enforcing the law versus a maintenance worker who's not. So does it make a difference depending on the position? An employee fired for making racially insensitive comments. Does it make a difference if it's a recruiter or a hiring officials? You know, those individuals have a responsibility, a direct responsibility for enforcing the EEO policy. What about a customer service representative? You know, I could think of arguments on both sides for that. You know, what about a clerical employee who may not have face-to-face contact with other employees? So again, depending on the particular situation, will dictate whether or not the employee is entitled to one of these name clearing hearings. One of the things that I wanted to make sure that I pointed out, though, is that it has to be, and it may have been on one of the other slides, that it has to be a false accusation. So if you have somebody who has admitted to the wrongdoing, there is no entitlement to a name clearing hearing. It's really somebody who believes that they've been wrongfully fired. They get the opportunity to clear their name so they can find work, again, in that particular field. And it's the second bullet here is that to be meaningful, the name clearing hearing must afford the employee a reasonable opportunity to publicly refute the charges against him by argument, witness testimony, or other evidence. So it's got to be some form of public hearing, whether it's, you know, I've seen public hearings held, you know, in the mornings, you know, on a Monday morning at 10 o'clock, or they allow the employee to, you know, have a certain amount of time at the end of a council meeting or other public meeting. So there are various ways to schedule the hearing so that it's, you know, to provide the due process that's due, but in the most or the least disruptive way. Just a couple procedural issues. Name clearing hearings have to be presided over by a hearing officer, but unlike in a regular due process hearing related to a termination where somebody's actually fighting for their job, it doesn't have to be an unbiased hearing officer. So, so you want to have somebody preside over the hearing. They don't necessarily have to be neutral. They don't have to be in, part of the disciplinary process, but it should also be someone who's not hostile to the employee. They don't have to be authorized to overturn the discharge, so it doesn't have to be the council, it doesn't have to be the city or county manager or another supervisor who would have that authority. You could have a third party oversee the hearing, you could have anybody else. It doesn't have to be somebody with that authority. And in fact, it's not even a hearing for the purpose of trying to get the termination overturned. It truly is an opportunity for the employee to say, hey, I'm being fired for a reason that's not true, and this is why. And then they move on and they've had the opportunity to clear their name, and it's really up to the next employer as to whether or not, they've sufficiently cleared their name or not. One thing that we always do try to emphasize to employees is that number one, they need to understand that this is not for the purpose of overturning the discipline. And it's also just as important that the hearing officer understands the purpose of the hearing too, so that there's no misunderstanding that the person is not going to be reinstated. Now, if something comes out that, allows you to see that maybe the decision was made in error, certainly you can remedy the termination at that point, but that's not the point of the hearing. And again, you just want somebody a hearing officer who is willing, to really narrow the scope of the hearing to relevant information. So, the person's not coming and they're not parading in witness after witness, to testify about the good character of that person or all the bad things that we as an employer did. So you want somebody who understands the hearing process that can control the hearing efficiently. These are just some other procedural considerations. There's no requirement, for them to compel witnesses through subpoena, whether or not you want to allow them to have witnesses while on duty, to employee witnesses, that's certainly up to you. Again, it's an open question whether the employer must make other employees available as witnesses. But we make the point here, doing so will make it difficult for the employee to convince a reviewing court that the hearing was inadequate. Let's see. The employee has a right to be represented by counsel. They don't require a record to be made, but just as I was mentioning earlier with the due process hearing for the municipal court judges, anytime you have any type of due process hearing, it's always a good idea to make a record of the hearing. That way, if it's challenged through any type of petition for certiorari or mandamus, which is a remedial procedure for a violation of somebody's liberty interest, you want to make sure that you show that you've done everything that you needed to do to meet the due process requirements. So, so making a recording of any of those hearings is highly recommended. I know that was quick. There's a lot more information in the handout that kind of goes more in depth, particularly as it relates to the name clearing and the liberty interest hearings. But we just wanted to put that on your radar if it wasn't already. I know we've talked about that before in some of our prior training sessions, but it's still something that we do see that's overlooked and don't often see employers offering that hearing for employees. So again, we just wanted to make a point, make sure it was on your radar. And again, there's more information, more in-depth information in the handout that you'll get following the.
I have a few questions here. Some of them go back a little bit of ways. So what is the OCGA of the liberty, interest, and name clearinghouse hearings?
Those are part of the Georgia and US Constitution. So it's part of the due process clause that you'll find in the 14th Amendment. And I can't recite the article in the Georgia Constitution offhand, sorry.
Okay. Shame on you, don't have that memorized. Here's another question. On the blood donation law, does that mean we have to provide specific paid leave for that rather than employees using their own leave banks?
Right. Yeah, let's see, it does provide for paid leave. Okay, right? Yeah. Receive up to eight hours of paid leave. So I guess the question is, does paid leave mean can they use their vacation, or do we actually have to pay them? And I would assume it's they continue to get their salary without having to reduce their accrued leave bank. But if I find out something differently, I'll make that correction.
Okay, so we'll send that out. Here's another question. This goes back, I think, to the first slide. Is an employee's if an employee tests positive for COVID, should we have them fill out a work comp first report of injury, or only if the employee requests it? It seems like it would be hard to prove it was contracted at work.
Yeah, I think I tried to make that point. I don't know if it came out very clear, but there are some states that have amended their workers' comp legislation to include COVID that is what is the word I'm looking for? That's contracted at work. But Georgia has not done that. And I mean, as you guys know workers' comp better than I do because I'm not a workers' comp attorney, but in order to be covered, it really for like some type of disease or illness, it has to be contracted because of the nature of the work that's done. And, I think that would be, I mean, the job that you're doing is not going to cause you to catch COVID, right? Unlike some industrial illness or disease that sort of, may naturally develop over time as a result of exposure to toxins and different things like that. So I think generally those types of claims wouldn't even fall within our workers' comp laws to begin with. And, you make the point that it's going to be really hard, especially in the environment that we're in right now, where who knows where you got it. I mean, if you leave your house, it's hard to tell where you actually contracted it. So to answer your question, I don't think that just because someone tests positive, I wouldn't recommend engaging in any type of workers' comp communications related to that particular situation.
And we have a webinar if you want to watch that. We had our work comp attorneys, Dan Niffen and others, answer those questions specifically about COVID when we initially came out. So that webinar, again, is in the list of our upcoming, actually, it's on the list of upcoming things, but it's within that particular list of webinars we've previously done. Last question here, and if anybody else has some questions, please ask. Is there a manual with just employee laws?
Like that you could purchase online?
Yeah, I would assume they are just looking for some reference to make it easy for them.
There are definitely resources out there. There's state by state resources, there's federal resources. I can't give any particular recommendation offhand, but there certainly are resources out there that have information in them about different laws that apply depending on the state that you're in. Yeah.
Okay. Will we still be receiving a copy of the slides for better reference? Yes, you will be receiving a copy of the slides, a recording, in one of Tracy's handouts. Again, this is not a question, it was a comment, just that they were very happy with the helpline services. So thank you for that comment. Anybody else have any questions or comments? Well, Tracy, thank you so very, very much for your presentation today. I think people enjoyed it. Here's somebody has a question. Do you need consent for someone to be tested? And what's the test? Can you provide more explanation on that? COVID. Do you need consent to be someone to be tested for COVID?
You mean, I guess I don't understand the question. For a person to, for the employer to require it?
Yeah, for the employer. So you got somebody comes in, you think that they are providing symptoms and you require them to have a test. Do you have consent to do that, or?
Well, at least the current guidance from the ADA allows employers to require the testing. So, you know, it's one of those sticky situations, which is, I mean, I don't think you can force somebody to get a test, but there are certainly consequences if they're not going to get the test.
Yeah.
Right.
So you wouldn't allow them, that would be part of your policy. You would not allow them to access your facilities. If you requested and they deny getting the test, then you would prohibit them from accessing your facilities, correct?
Right. I wouldn't pin them down and and you know, have the test, but yeah, I mean, you know, again, and you can't force somebody to do that, but there are consequences. You can require it. You can't force someone. If they choose not to abide by the requirement, then they suffer the consequences. But yes, you can require employees to be tested as long as the pandemic is active.
Very good. And again, it gets back to having policy and being consistent and other things in regards to that. Any other questions or comments?
Yeah, I was just going to say, you know, the COVID-19 stuff, you know, you guys have been navigating it side by side with us, and it just, it's been a whirlwind. It's just, you know, just as soon as you think you have something down pat, something happens, or the law changes, or, you know, and so it's really hard to stay on top of all that. But, you know, I will say, just for, you know, your own benefit from a resource standpoint, I will say that I frequently go back to the, frequently check the CDC website. They've done a great job, at least recently, updating a lot of the workplace information about what you can require, what you can't require, and, you know, and all of that kind of stuff. The EEOC has an entire section related to, you know, medical tests and what can you ask, and, you know, what are the limitations from a, you know, inquiry into medical information. So I frequently check that. And then with regard to the Family First Coronavirus Act, I often look at the Department of Labor website and the regulations that they issued for employers on how to administer all of that paid leave. So those are really good resources, and I frequently also check the Georgia Department of Public Health, and they tend to do frequent updates on their administrative orders, shelter-in-place orders, isolation and quarantine orders. And what I found is the isolation and quarantine orders pretty well track the CDC guidelines. And again, I mean, I think those just changed, and now they're saying 2 negative tests, you know, we shouldn't be following that anymore. It's, you know, we should be following the time-based method. But anyway, if you guys have questions about that kind of stuff, I'm more than happy to walk you through it, because it's, you know, it's very complicated, and I know y'all are trying to deal with all of that. So,
again, thank you. I will include a couple links to the COVID things we've done previously. If people want specific knowledge on that, it gets in pretty in depth. So thank you all for your participation. Thank you so much, Tracy. Really enjoyed it. And I will again be sending an email with all this information out later today. You all stay safe and healthy, and let us know if there's anything we can do to help. Thank you so much, Tracy.
All right. Y'all have a good afternoon.